All right, it's coming up on 2 o'clock. I know a lot of people are still signing in. I'll start with the introduction. I'll go slow so that people can continue to sign in, but we do have a lot of information to cover today, so I don't want to wait too much longer before getting started. Good afternoon or good morning, depending on where you're joining us from today. My name is Brent Connor, and I am Senior Counsel in the Washington, D.C. office of Thompson Hine, and I practice in the International Trade and Transportation Practice Groups. On July 1, 2020, the United States-Mexico-Canada Agreement, the USMCA is as we call it in the United States, will replace the North American Free Trade Agreement. Hopefully this is already on everyone's radar. The trilateral free trade agreement will affect many facets of North American economy. And in this 4-part virtual roundtable series, we'll help you navigate the USMCA provisions affecting companies and understand the rights and obligations of the member countries. So our discussions include counsel from law firms in the United States and Mexico and Canada and representatives from companies addressing these issues firsthand. I'd like to welcome you to today's USMCA webinar. This is session 3, what happens at the border, trade facilitation, and practical questions. Our next scheduled webinar is next week, July 1st, the day that the USMCA comes into effect, and we'll address USMCA supply chain issues. Before we begin, I'd like to cover a few housekeeping items. Today's program is being recorded, and we'll send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box that's located in the control panel on the right side of your screen to submit questions. We'll answer as many of the questions as we can at the end of this webinar. In the handout panel, also to the right of your screen, you can download a copy of the PowerPoint slides as well as the bios for each of today's speakers. So again, thank you for your interest, and if you have questions as we go along, please use the question box. I'm delighted to introduce the panelists today. I'm just going to advance the slides. Okay, there we are. All right, so I'm delighted to introduce our panelists. I'm, as I said, Brent Connor. I'll be the moderator. But joining me today are Alejandro Luna, a partner with Santa Marina and Steta in their Mexico City office, and Clifford Sosno, a partner with the Canadian law firm Fasken Martineau in their Toronto office. So here's an overview of what we hope to cover today. I'm going to give a brief background on trade facilitation. We also want to talk about the white elephant that's in the room, and that's the current border issues in light of the COVID-19 pandemic. So we'll touch upon those as well. And then we'll dive into significant trade facilitation provisions that are in the USMCA. For these provisions, time won't allow for us to drill down as much on each one, but we're going to try and cover significant matters like, the impact on that the specific provision could have on goods crossing the border, or any challenges that I or the panelists might see, and then any anticipated changes that we think have to be made to US, Mexican, or Canadian domestic laws. So first, in terms of a background on trade facilitation, there were no trade facilitation provisions in NAFTA. NAFTA is, a pretty old agreement dating from the early 90s, and trade facilitation wasn't really on anyone's radar at that time. And of course, it was the first, trilateral agreement for North America. But as things developed, traders and signatories and parties to these various trade agreements realized that, yeah, it would be helpful to have, some trade facilitation provisions adopted and added to the trade agreements. So a significant trade facilitation agreement was first adopted as part of the WTO agreement. The parties negotiated the trade facilitation provisions. Those negotiations concluded in 2013. And then there was a threshold number that was required in order for the actual trade facilitation agreement to come into effect. And that occurred in 2017 when 2/3 of the WTO members finally ratified the trade facilitation agreement. And now it's in effect since that time. So when the USTR got involved with renegotiating the North America Free Trade Agreement and it became the USMCA, they really wanted to add a trade facilitation chapter to the USMCA, and they wanted it to be the gold standard for future trade agreements. So think about that as we go through these provisions. One of the things that they had on their radar was a free trade agreement with Europe. So some of the things that are significant for our trade relationship among the North American countries, it's going to be even more significant when you think about a US EU free trade agreement, for example, where you have what, 27, 28, parties on the other side, conceivably. So it's kind of an interesting factoid to keep in mind as we go through these. Before we start drilling down on the trade facilitation provisions, however, I want to talk about, just for a minute, again, this white elephant in the room in terms of, what are traders currently experiencing given the pandemic and the fact that the borders are closed for tourism and leisure travel. I'm going to throw it open to Alejandro and Cliff in a moment, but I just want to read the statement that the U.S. issued. Now, they're referring to the U.S.-Canadian border here when it was being closed to leisure and tourist travel, but open for essential travelers and essential goods to be transported. The U.S. stated that border restrictions, quote, should not interrupt legitimate trade between the two nations or disrupt critical supply chains that ensure food, fuel, medicine, and other critical materials reach individuals on both sides of the border. I mean, that applies to the USMexico border as well. It's the same standard. So I'll open it up to Alejandro. Why don't you tell me what, if anything, you're hearing? If things are running smoothly, that's good news. We want to hear that too. But what's happening at the U.S.-Mexico border in light of what you're hearing?
Sure, thank you, Brent. Good morning, everyone, or good afternoon, everyone, depending on where you are. Thank you for inviting us to this webinar, and we're very pleased to participate with both Thompson Hine and Fasken. And as concerns your question, Brent, we have not perceived that much of a delay directly at point of entry of goods into Mexico, okay? There are certain areas that have had delays for two reasons. Maybe a change of policy in the energy sector where we've seen certain hydrocarbons being stopped at the border for greater verification of that particular good coming in, okay, and because or due to a delay in in the laboratory performing the tests upon those particular goods, the official customs laboratory performing testing on that matter. And we've also seen certain delays caused by suspension of terms in other governmental agencies that have, of course, to do with trade, in delays in issuing permits or certifications. We'll mention something on the single window further on, of course, but having said that, there is some delays caused by lack of manpower, physical manpower, in view of restrictions on work in governmental agencies, even directly at the border. But fortunately, those have been minor. We've seen a good flow of goods versus people, where we have seen, of course, issues in crossing the border directly at border points, land border points, mainly, okay, with the US, more because of the health and security provisions affecting that flow of per people rather than goods. But
Okay,
I think,
all right, thanks, Alejandro. Cliff, how about, whoops, sorry. Cliff, how about on the US-Canadian border? Are you hearing good news, bad news? What's the status?
I would say much better news now than obviously from the earlier start, just simply because everybody was trying to better understand how things needed to play out. There still is some lumpiness in the border. That lumpiness is in terms of a common understanding of what is an essential service, and some border officials sometimes need to contact public health officials to determine whether something is essential. And that sometimes causes delays. We're still hearing about delays because border time and border resources are reduced. Some border entry points have simply shut down over certain periods of time, and that's caused delays in shipments. But there's also problems with respect to drivers. They're required to wear masks. Some of them have the masks, some of them don't. Some of the border officials don't have supplies to give them. So there is a certain amount of lumpiness at the border. I wouldn't call it a crisis at this stage of the game, but it's overall it's functioning smoothly. But we're continually hearing about problems of individual shipments that are being held up because of that that uncertainty and that unevenness of application of the criteria.
Yeah, and traders,
a lot of the delays also have to do with the supply chain itself, no? And the restrictions posed on manufacturing in other parts of the world, not necessarily proceedings, governmental proceedings or agencies restricting importations or exportations and the like, no? But rather an indirect consequence of that supply chain affectation.
Right, that's right. That's right.
Right, there can be a lot of complicating, factors here, just beyond what's happening directly at the border. It's a good point, Alejandro. Cliff, let me ask you, does Chapter 7 have any provisions that could minimize disruptions at the border, like some of the ones that you've pointed out? I mean, it's good to hear that on the whole things are going well, but there have been some hitches, right? Which is understandable. Do you think there's anything here in the trade facilitation provisions that might help?
Well, there are requirements to submit documentation now electronically, and to allow the documentation to be submitted electronically, and presumably that means less time at the border itself. There is provisions that deal with managing risk and using trusted trader programs. And hopefully that reduces some of the risk associated with border points, again aimed at smoothing the border. The agreement also does contain a trade facilitation committee that enables administrators to speak to each other to talk about particular shipments, pending shipments, and how the border is being managed. And so presumably some of those issues will be managed as well. And then there are provisions that talk about the release of the goods without having to pay duties or taxes on provision of certain security. So again, all of these things are intended to thin the border, to make the border a little bit easier to manage, to make the wait times at the borders a little bit lower. In an ideal world, they all run smoothly. Will they prevent the situation of border guards not having enough masks to give drivers? No, they won't. Will they prevent border officials from having a certain amount of inconsistency in the application of federal law? No, it won't. Will it minimize that risk? Yes, it will. And so it's not going to be the panacea. It's not going to be a snap your fingers and everything is going to be okay with the border, but it is going to be hopefully, when it's all implemented, a means of minimizing the friction of regulatory requirements that just compounds the problems that the pandemics create.
Yeah, those are all good points. I'll also point out that in addition to the Trade Facilitation Committee, there's that new provision on communicating with traders at 7.3 of Chapter 7. And, you know, this is something that the USTR was really keen on because they wanted to provide traders with an opportunity to raise emerging issues and provide views on the procedures, and especially a way to deal with delays and loss of business and difficulties. The USTR has indicated that they haven't heard from traders enough on customs issues. And again, this is the having trade facilitation provisions in a free trade agreement is still relatively new. So they want to hear more from traders. So all of you traders out there, look for notices from USTR and the Federal Register, at least on the US side, and other opportunities when this Trade Facilitation Committee is finally stood up. Nothing's going to be a quick fix, but compared to NAFTA, at least there is now a vehicle for traders to be heard specifically with regard to these types of issues. All right, so let's leave this issue for the time being. We could go on and on about it, but let's start getting into, if I can get the slides to advance.
I agree.
Trying to advance to the next slide. There we go. Whoops. All right, so now we're going to dig in on the actual provisions within the trade facilitation chapter of the USMCA. So these provisions are found at Chapter 7. It's entitled Customs Administration and Trade Facilitation. We'll just jump in here. Cliff, I'll turn it over to you to kind of brief us a little bit about the advanced rulings provision.
Right. Okay. So the advanced ruling system did exist in NAFTA. For those of you that are not familiar with advanced rulings, they're basically a binding opinion that's issued by the government with respect to the importation of a good prior to that good coming in. And it's a discussion in a decision and a ruling by the government as to how they will treat that good. Under the NAFTA, tariff classifications and origin were proper subjects of advanced rulings. If you were not sure about whether or not you're going to be bringing in a product, if it would meet the origin rules, if it was a US product, a Mexican product, or even a US product coming in from a Canadian product coming into the US or Mexico, you could ask for this advanced ruling. Similarly with respect to tariff classification. What the USMCA has done, and if you want to show that you're an absolutely brilliant person, you will refer to it as the CUSMA, because in Canada they call it the USMA. At least government officials do. So you'll get a gold star for that. That's been expanded to allow for advanced rulings as it applies to the application of customs valuation criteria. In other words, if a particular product is intended to be brought into a country, what will be the value for duty and what valuation criteria will be assessed by regulators as it applies to that particular product. Ultimately, how much is this going to cost? The other is the question of whether or not something falls within a quota or a tariff rate quota. Again, for those of you who do not know, a quota is a limit on volumes of imports. Below the quota limit, goods can come in. Above that quota limit, goods cannot. A tariff rate quota is below the limit. A certain limit, goods come in at a very low rate. Above that limit, goods come in at a prohibitively high tariff rate. Advanced rulings now allow for that. In Canada, that is important because there are several goods, especially in the agricultural space, that are subject to these quotas. What else is different than in the NAFTA? Well, the NAFTA did not require an explanation. If something was approved, typically in advanced ruling, you submit documentations and you tell regulators, this is what I think is the ruling that should apply. Under the NAFTA, if they agreed with you, they just gave you your decision, and they didn't tell you that they've approved it or why they approved it. They just simply told you if they rejected it, under the USMCA, they have to give you reasons why they approved it. Why is that significant? Because if you have similar goods in the future, you can use that ruling as a kind of indicator for you as to how you might want to manage those similar goods. Under the USMCA, the ruling has to apply throughout the territory to the person to whom the ruling is issued, and that's important. The advanced ruling only applies to the person to whom the ruling is issued. So if somebody else has the exact same goods, that advanced ruling doesn't apply to them. They can use it, but they can't rely on it and bind the government to that ruling. And this uniformity of application at a practical level means that at all entry points in the territory of a country, there has to be uniformity of application with respect to that advanced ruling. The other issues that the USMCA deals with as it applies to the advanced rulings that were not dealt with in the NAFTA is that a ruling must be issued within 120 days after necessary information is received, and it also becomes effective on the date of the issuance of the ruling. Now, in Canada, there is some limitations on that, in that the border officials, they're called the CBSA, may ask for additional information, and typically there's a 30-day period to respond. And if there, yep.
Just real fast, I just want to ask you a question, because we do have a limited amount of time here, and you're absolutely right. I mean, that's been helpful with regard to the advanced rulings. You know, it's a step up. It's gone a little bit further than NAFTA. It has to apply uniformly, as Cliff said. That was a huge issue for USTR because there have been variations or you know, certain rules haven't been applied the same way from port to port. So that was another important point. But I do want to make sure that we have time to cover some of the other provisions here. So I just want to ask you, though, really fast with regards to advanced rulings. Do you think that advanced rulings that were issued under NAFTA, would those apply under Chapter 7 of the USMCA? For example, if you had the same exact good at issue and the same exact components and supply chain. I mean, what do we do in that situation if we have a NAFTA advanced ruling? Can we still rely on it?
Right. To those of you who are wondering, I basically finished my presentation with respect to advanced rulings, but under the, at least in Canada, and I'm assuming it applies the same in the US and Mexico, an advanced ruling issued under the NAFTA does not apply to the USMCA. Even if it's the same goods, even if it's the same supply chain, Canadian officials will say that was then, this is now. And so on June the 30th, all advanced rulings basically disappear. Now, I would make the observation that if you're dealing with the exact same goods, even if you're dealing with a different tariff classification number, if the tariff classification is exactly the same, if the rule of origin is exactly the same, then it's highly likely that you continue on keeping the way you're going. But if the description of the tariff classification has changed or the origin rule has changed, then I would think that that should be a red flag to you, that you can no longer use that origin or advanced ruling rather. I should also say that for products that are in transit, where they're shipped on June the 30th, but are going to arrive after July the 1st, at least for Canadian officials, they will respect the old advanced ruling under the NAFTA.
Great, thanks, Cliff. All right, so I'm going to move to release of goods under, this is Article 7.7, Chapter 7, real fast. So under the release of goods provision, each party is required to adopt simplified customs procedures for the efficient release of goods. Of course, this is to facilitate trade among the parties, and the procedures have to provide for the immediate release of goods upon receipt of the customs declaration and any other required applicable procedures. And the provisions in the USMCA say that the parties must allow goods to be released at the point of arrival without requiring temporary transfer to warehouses or other facilities. So if the goods aren't released right away, the party, country, has to inform the importer right away as to why. So I'll just say from the US perspective, we already have a special permit program right now for goods coming in from the United States and Mexico. That's especially important, this time of year with regard to all the produce that's moving across the borders. It's, time sensitive. And so you can get, apply for the special permit to have immediate release of the goods. But I think one of the challenges here in moving to this requirement under the USMCA is that the onus is really going to be on traders to get all their ducks in a row and make sure that everything's in order. Is your packaging right? Is your marking, your labeling right? Did you mix, in the same package goods that have different values such that you're begging for a customs inspection? I mean, what you want to do here is set yourself up so that customs will grant the special permit if that's the program that they're going to continue with, and we don't know. There might be a different regimen that's adopted. But the point here is make sure that all your ducks are in a row so that you're not giving customs an excuse to delay that immediate release and not waive an inspection. So I'll stop there with regard to release of goods. Cliff, I'll turn it back over to you for express shipments.
Okay, very, very quickly, the NAFTA didn't deal with de minimis levels, de minimis thresholds. Again, for those not sure, de minimis thresholds are amounts below which neither duties or taxes are imposed. The USMCA specifically addresses this issue. In the US, that amount is $800. In Mexico, it's $117. In Canada, it's a little bit below the 117. It's 150 Canadian, which works at the current exchange rate to about 113. And then on the tax side for the US, it's 110. For Mexico, it's 30. And then for Canada, it's 40 Canadian, which is about $30 US. Now, this higher de minimis threshold only applies for courier shipments. It doesn't apply for postal shipments. And courier shipments are those that are delivered by a commercial carrier engaged in scheduled international shipments. So the eBays of the world are not happy with this. UPS and FedEx are happy with this. There is a simplified release under these systems. Under the USMCA, a commercial invoice is required. No origin documents are required. There's no need to account for those documents. Once you get to the $40 threshold, for example, in Canada, you have to pay taxes, and at that point, you start having to pay to submit accounting documents. I should note for everybody that this also does not apply to transshipped goods, and it also does not apply to goods from, let's say, Europe, Italy. It's only specific to the US, it's specific to Mexico. And you should also know that at least for Canada, things like alcohol, cannabis, and cigarettes are excluded from the benefit of the minimum threshold. So if you're going to be using that, importing that, or exporting that to your buyers in Canada, don't expect the UPSs and the FedEx to be able to benefit from those minimum thresholds. The USMCA also addressed the issue of low-value shipments, under which fewer customs formalities are required. For the US and Mexico, it's $2,500 US. For Canada, it's $3,300 Canadian, which works out to a little bit under $2,500 US. And again, the lesser customs formalities are only a commercial invoice. There's no need to provide origin documents. If you're dealing with trusted couriers, they can account for the goods at a later time. They don't have to account for it now. Typically, it's 5 days after entry in Canada. Under the new system, it's the month following. But a note to all those that are using the low value shipment, at least in Canada, officials have made it very clear that they want records to be maintained. And this includes commercial invoices and accounting documents, because they have let traders know that they can do verifications at any time to make sure that the low value shipment process is not being abused.
Thanks, Cliff. So one of the things to keep in mind here is that when NAFTA was adopted, there wasn't really such a thing as e-commerce. And now e-commerce is really flying, right? So these are the provisions that at least the parties were able to agree to. Hopefully there'll be continued dialogue on this, and we'll see increases in the dollar amount so that the lower or the more minimal or the fewer customs formalities will be applied to more and more items. A couple things to point out as well: there's no definition in the agreement on what minimum documentation is or what fewer customs formalities are. So, that's going to have to get ironed out, and we'll have to see how that develops. Alejandro, let's talk about the single window system. Let me turn it over to you.
Sure, thank you. This single window is foreseen under Article 7.10 of this Chapter 7 within the USMCA, the TMEC, or the CUSMA. No? And of course, there was a very particular provision in which it said that such single window system through which all customs proceedings could be filed electronically to facilitate trade, to expedite trade, to reduce costs involved in performing importations or exportations should be implemented no later actually than December 31st, 2018, which was strange because it was prior to it coming into effect. Of course, the three countries already had single window, national single window systems, and to an extent even Canada and the US shared a common ground there with the single window initiative and the IID and the LCOP through those two options in Canada, the ACE in the US, and here in Mexico through the BUSM. No? But this provision specifically provides for the expansion of the single window systems in the three parties so that it can greater facilitate trade in goods and make them quicker in being, of course, cleared in customs for all of these proceedings, permits, certifications that are needed to be obtained through that single window system. It calls for the WCO data model to be implemented therein, and for all of this process to be streamlined, to add processes there, and working towards a common harmonization of data elements so that it can be facilitated. No? This is the first FTA to have this provision, although it was easier to adopt because the three countries already have it. No? But it looks for compatibility of each system, for the three systems to be compatible. And of course, it endeavors to an extent to be as a basis for future free trade agreements of the US and even of Canada and of course Mexico, more in the model of, for example, ASEAN, which has adopted this type of provisions of single windows, and even to an extent CAFTA and in Central America and the like has been seeking that and has been provided funds through the international Inter-American Development Bank, no, to that effect. No? But it is an advancement, and we hope that it fully integrates the systems eventually. No, that would certainly be good news in this, but it will take time. Of course, it requires investment by each government, and of course a lot of communication by traders with their governments as to functionality and the like. No suggestions thereat. No?
Right. Thanks, Alejandro. Yeah. So look, this was kind of low-hanging fruit for the parties to get this into the agreement because they each already have a single window system. But as Alejandro points out, the point here is to get those systems to become compatible so that if you're filing in regard to an export in one country, you're at the same time filing in regard to an import in the other country. So the challenge is to how do we get these three single window systems to be compatible so that we bake in that kind of efficiency. And then from the US perspective, of course, this was adopted with an eye toward free trade agreements where a single window might have a greater impact, like an FTA with the European Union, where you're dealing with a number of different countries on the other side. All right, Cliff, let's talk about risk management. I'll turn it over to you.
Right. So the USMCA, again, this is a new provision, and under the heading of thinning the border, is trying very hard to make two categories of shipments: high-risk shipments, low-risk shipments, and move away from the system of applying all kinds of resources to every shipment. It just doesn't work, and it just causes the border to shut down. And so the USMCA basically obliges each of the countries to develop systems that they haven't already, and I think in our situation they have already, creating systems for inspection of high-risk goods and creating systems to simplify the release of low-risk goods. Now for Canada, what are the systems that are used to identify high-risk goods? Well, Canada uses two programs. One is called the Integrated Customs Enforcement System. They have a data bank where they determine whether any trader, courier, or carrier for that particular trader has any warrants issued against them, a criminal record, consistent customs violators. Their shipments are immediately red lighted. And then there's also called a pre-arrival system or a PAR system in Canada that allows border agents to review shipments before they come to the border, to review them to see if in fact pricing matches the product, matches who the shipper is. I was involved in a fraudulent scheme, not involved in it, but representing a company that was charged with a fraudulent scheme. And they thankfully were not part of it. But shippers were using, they stole their internal documentation and were using that documentation and giving numbers to shipments that just weren't making sense in relation to prior shipments. And they were able to identify the fraudsters using this pre-arrival system. So they use these systems to basically identify both persons and goods. But they also have, assuming it's the same in the US and assuming it's the same in Mexico, systems of trusted traders. And the whole point here is to say, if you're trading with this particular trusted trader, we are going to spend less time looking at your shipments. In fact, we may not look at your shipments at all. In Canada, there is a partnership and protections program, and that partnerships and protections program is based on the World Customs Organization SAFE framework. And basically, persons have to determine or be assessed as to their solvency, whether they've got any criminal records, whether they've got a record of compliance with the CBSA's customs rulings. And if the answer is yes to all of those, they're basically given a reduced risk score. And that just signals to officials that when you're dealing with these particular traders, you don't need to stop every shipment. You don't need to ask questions with respect to every shipper. You can let those shipments go. I will also say that the USMCA does require countries to periodically review their management systems. In Canada is in the process of reviewing its Partners in Protection program, and that's slated to be finished in 2021. I also would suggest that for traders that are looking at finding importers in Canada, that they make as a condition of their commercial contracts, to the extent that these will be chronic shipments, that is a condition of the shipments that their importers be participants in these trusted trader programs. It just simply, especially in a COVID environment, removes an additional layer of friction at the border.
Great, thanks, Cliff. So I just want to remind attendees, if you have questions, go ahead and use the question dialogue box. It looks like I might have one question. We want to cover a couple more. Oh, we do have a couple questions. Okay, that's great. All right, we're just going to get two more points real fast, and then we'll get to the questions. 1 second. All right, so Alejandro, why don't you cover post-clearance audit real fast, and then we'll move to the questions.
Sure. This agreement under this chapter in particular, the provision 7.13 provides for or how post-clearance audit should be favored by both nations, by the three nations, I'm sorry. And the purpose of this is to expedite the release of goods. No? Previously, of course, especially in places like Mexico, you could have, in Mexico in particular, you could have a customs administrative proceeding in situ at point of entry of the goods, and they would be delayed weeks on end because of that. And now each party is promoted to instead of performing this type of proceedings at point of entry, to perform them actually post clearance, after the goods have entered the country, on a risk-based approach, which is good. No, determining the risk and only performing them upon greater risk in that type of importations, and thus expediting the release of goods directly. No. This is looking for transparency, good rule of law, application of principles of good rule of law through that, and the decisions and determinations must be made very clear to the importer of record, for example, or to the exporter, and notified duly, okay, with predictability as to the results, etc., increasing through those means. No? This provision, for example, contains a very specific provision for Mexico, no? Which it must provide a fixed or finite period of time for record keeping, no? Which would be the 5 years here in Mexico that the general fiscal law or tax law provides for. And that is very good because, for example, machinery and equipment previously, you'd have to evidence its legal stay or its legal importation into Mexico for an indefinite period. And now with this provision, if you only need to keep records and you could call for that, this will probably determine something that even in the judiciary has caused issues in determining whether that be or not. No? Okay. Thank you, Brent. I don't know.
Yes.
So I just want to, we have a question. We're coming up on 2:45. It's 2:42 now. We do have a question from an attendee that I want to get to. The attendee writes in and says, there will not be a specific form to certify origin. It used to be CBP form 434. So that would be the NAFTA certificate, for example. The producer, exporter, or importer can provide the required 11 elements to certify origin as applicable. And the question is, will customs offer guidance on how to comply with the new USMCA origin certification if the former CBP 434 was provided for the import? Or will this just be denied and tax or duty applied? So Alejandro and Cliff, what are your thoughts on how to proceed in that regard?
Me in particular, from the Mexican side, I would, especially with the new rules of origin, especially if the new rules of origin affect the particular good that you are exporting, I would recommend those advanced rulings. And there will be guidance. There are provisions within this trade facilitation chapter pertaining to guidance to be provided and the obligation of guidance to be provided by the customs authorities. There will be changes, and this certification process, of course, is very different now. It relies on a lot of good faith, but at the same time, it mandates that you maintain very good records and demand such good records from the exporter in turn. No? By the importer. So I would definitely recommend seeking, if there's doubt, these advanced rulings to which Clifford addressed.
Yeah. Okay, thanks. I think the question goes more to format on how to show customs that what the country of origin is, because they say, will customs offer guidance on how to comply with the new USMCA origin? You know, they call it a certification, but it's not really. There's no formal certification available. One way to deal with this is to go to the uniform regulations that spell out exactly what needs to be in the document that you get from I would recommend that you get it from the producer, which often is the exporter, right, your supplier, because they have the better information. Make sure that they understand what the data elements are and that they are hitting all of them in the document, which can be in the form of a letter. Some trade associations I've seen are coming out with forms. They're just informal. They're not CBP forms, but they're informal forms for a producer or an exporter to fill out. Cliff, I don't know if you have any thoughts on how to deal with this, where the NAFTA certificate is going away and we're left with kind of this free flow or free form certification process.
Yeah. Well, I mean, two things. One is, as border officials will not provide guidance on what origin criteria applies beforehand. And under the old system, the exporter provided certification with respect to that, and if there was any problems, there was issues of who bore the ultimate liability for not being able to meet certain contractual requirements. The problem now is that the importer is left in a situation of, if they're being required to certify, they're really certifying on origin without access to manufacturers or exporters' books or records. And yes, there's a reliance function on the manufacturer or the producer, but the truth of the matter is they may not know who that manufacturer or producer is very well, and there may be limitations on how much information is required or will be shared. And so the importers really are, under the USMCA, put in a much more difficult spot in terms of that issue of getting the origin right. And so it seems to me that to the extent that you are an importer, that you offload on the certification requirements as much as you possibly can from the exporter or the producer, what they consider to be the rule of origin that applies to the good and why they consider that in the light of the information that they're relying on. And that enables you, before the actual importation takes place, to make an assessment as to whether or not you agree with that assessment. And if you don't agree with that assessment, have that conversation with your producer or your exporter down your supply chain, because as the question knows, if you get it wrong, the liability is on you, on the importer. You're going to have that additional tax. And since you're the one who's certifying the accuracy of it, you're not going to be able to go back to the producer or the exporter to seek loss for that liability. So it's a much more difficult process, really, for importers. It's really important for you as an importer to have those conversations with your producer and exporter to make sure you're both on the same page. And of course, when you're dealing with autos, the rules of origin have really been thrown on their head. The advanced ruling is the ideal, but the truth is that it's a 120-day period, and that just may not be good enough. And so obviously, it's just important to have that really deep understanding of what the rules of origin are, particularly as they apply, for example, to autos. The rules really have changed significantly.
Right, all good points. And I guess that goes back to where Alejandro was going with his comment in terms of, look, if you have a question, I think, Alejandro, what you were saying with regard to these new rules of origin, does it make sense to get an advanced ruling? And your thought there?
It would definitely be recommendable because the issue here, as the certification is more reliant on the importer now rather than the exporter, and no free form it's in free form format, you'd have to have greater certainty, and you can only reach that through this type of ruling previously. But of course, that needs to be obtained by the exporter eventually. So that may be mandated eventually by your importers.
Right. Exactly. Well, listen, I want to thank both of you for joining us today. We've gone over about 4 minutes. I do have another housekeeping matter that I have to attend to. But again, thank you so much, Alejandro and Cliff, for helping. I apologize to the attendees. We were not able to get through all of the specific provisions. We were able to cover some of the significant ones, though, from Chapter 7. Feel free to go to the USTR's website, access that Chapter 7 look at the provisions, see how you can take advantage as a trader, and keep an eye on what changes are going to be happening with the new USMCA coming into place to move goods over the border more efficiently. So one other thing, if you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Thank you all for your interest in attending today's webinar. Enjoy the rest of your day and stay well. And thanks again to Cliff and Alejandro. All right, take care, everyone.
Thank you. Good afternoon.
Thank you.
Bye.